Okay, so now you've seen the Chevron two-step, and maybe some of you are thinking that perhaps I should assign a dance number as a final exam for this class instead of another multiple choice or essay exam. Well, we'll see about that. In any case, of course, the video goes by too quickly for you to take in the lyrics, and so I posted the lyrics of the Chevron two-step on the B Courses site somewhere. We'll find it. Anyway. As I think I mentioned briefly in class a week ago, the Chevron doctrine has become lately controversial. It came up during the hearings for the confirmation of Neil Gorsuch for the Supreme Court, and there's an awful lot of literature about it these days in law reviews and elsewhere, lots of conferences, lots of discussion. The idea is Chevron deference, which we'll describe when we come to the case. It's not something that is a bolt out of the blue recently, or something that was brand new when the case came down in 1984. The idea is, when do courts defer to legislatures, and how do they defer to legislatures, whether it's the reach of the Commerce Clause, the reach of the police power, or any of the other clauses of the Constitution, contracts and so forth. And in fact, the first instance perhaps of the court suggesting that it should defer to legislatures, especially in matters of regulating economic affairs, begins, I think we saw in the slaughterhouse cases, but I think more clearly in a case from the 1880s called Munn versus Illinois, which dealt with state regulation of grain elevators. Now, I think I should spend a little bit of time talking about the general background of the law and the development of the industrial economy of the late 19th century. As everybody knows, we had the rise of industrial capitalism, whatever you wish to call it, but of large-scale industries spreading across multiple states. The railroads, of course, big steel companies, the trusts, the robber barons, as we like to call them, in connection with some of these larger industries, oil refining, and so forth. And we developed antitrust law and antitrust statutes, and our first regulatory agency, the Interstate Commerce Commission, in the 1880s. And the Supreme Court and a lot of states had the regulation of things like railroads operating inside the state borders. One of the difficulties posed by a whole slew of the railroad rate cases, which we're going to skip over because they're very long and can get rather tedious. One of the issues of those cases was, yes, it's legitimate to regulate the prices of these quasi-monopolistic industries, but at what point does regulation go too far, like we saw in some of the takings cases, and amount to the confiscation of the rightful property or the profit margins of private investment in companies like railroads? Railroads are a special problem because they operated in a marketplace that could not be perfectly competitive. One of the perversities of railroads that led to the Interstate Commerce Commission in the first place was this simple fact. If you wanted to ship something from, say, Philadelphia to Chicago, there may be 3 or 4 routes you could pick and 3 or 4 competitors on different rail lines. And because they competed, the price per mile was fairly reasonable. On the other hand, if you wanted to ship something from, say, Philadelphia to Reading, Pennsylvania, inside the state borders, a short distance, what you would find is that the price per mile was very high. This was known as the short haul, long haul problem. And so, for example, it would work something like this. Suppose today, if taking a Southwest Airlines flight from Oakland to San Diego cost you $500, but it only cost you to fly from Oakland to New York City for $200, you'd say something's clearly wrong here. And that was the phenomenon you saw with disparity in railroad rates in the 1880s. There'd only be one railroad, of course, between Philadelphia and Reading, and that's why they could charge monopolistic prices. It's more complicated than that. There are actually some reasons for some price disparity on the per mile charges. Long haul rates from, say, Philadelphia to Chicago would reflect the fact that the train didn't stop as much, you didn't have as much or as high of labor costs of loading and unloading and shifting cargoes around. So it wasn't simply that the per mile charge was the only thing you cared about in regulation. And that's one of the things that made it so complicated. The next problem is, if you're a court, is you have not only your operating costs, your fuel, your maintenance, your wages for your employees, but then What price should you be allowed to charge to recoup your capital costs? I mean, you've put a lot of money investing in putting down rail lines and train stations and so forth. And of course, it's quite just that the people should, who the companies should recover their investment over time. Well, what time is the schedule for that? What discounts rates do you use? Lots and lots of economic calculations will go into coming up with the result of this. And some of those railroad rate cases from the 1880s and 1890s had the Supreme Court going through essentially the books like an auditor would. And finally, the Supreme Court, after many of these cases, came around to saying, let's have regulatory commissions set the rates. They have to be fair and just and reasonable. But the main point is the federal courts do not want to become super rate setting agencies. If every time a railroad or later an electric utility, a water company, and so forth, if every time they're upset that their rate of return isn't high enough, we don't want them running the federal court and having the federal court adjust the rates. And so this begins the whole world that we know now of public utility regulation that works on the one hand badly and on the other hand actually pretty well. In other words, lots of reasons for second guessing it, lots of problems with public utility regulation. But compared to what? Compared to a world with no regulation, you'd obviously have monopoly profits taken from these natural monopolies like electric utilities. Or you'd have endless cases clogging up the courts, with courts having to become accountants, essentially. And no one wants that either. So the situation we've got is probably the best you can come up with in the real world. And so by the late 1880s, we had established our first independent regulatory agency, the Interstate Commerce Commission, which represented the first significant delegation of power from the legislative branch to the executive branch. The Interstate Commerce Commission and most of the earliest regulatory agencies, like, for example, the Food and Drug Administration, started in 1906, had very limited scope of what they were regulating and very precise charges or directions from Congress on how they were supposed to regulate, and fairly confined regulatory powers. For example, the Interstate Commerce Commission originally did not have the authority to set rates. Instead, by a curious arrangement, railroads would send in suggested rates, and the Interstate Commerce Commission could either do thumbs up or thumbs down. They could either approve them or reject them, and then the railroad would have to come back with a new proposal. That changed with the Hepburn Act in 1907 because that arrangement really didn't work very well. And from then on, the Interstate Commerce Commission had direct authority to set railroad rates and later trucking rates when the trucking industry came under the authority of the ICC. Of course, the ICC was abolished in the 1980s, but that's a story for later on that needn't detain us now. Now, from here, we want to move on to a different vector of the regulatory problem, and that's the 1876 case of Munn versus Illinois. Now, this dealt with the regulation of grain elevators, which, while not exactly monopolistic, they were more like food co-ops today, which still exist, of course, for a number of industries, like fruits and nuts in the Central Valley. But they did have some monopolistic characteristics because everybody tended to go to the one local grain elevator and pool their products and so forth. The state of Illinois had instituted a program to regulate the prices charged to farmers who stored their grain in the particular elevator near Chicago. And the price regulation was challenged on due process grounds. That is, it was a deprivation of the rights of the grain elevator owners to charge whatever price they wanted. And in a decision by Chief Justice Morrison Waite, he appealed to a term out of English law, talking about an industry that is, as he put it, affected with the public interest. Here, early in the opinion, in paragraph number 4, we see Chief Justice Waite trying to define the idea of affected with the public use by saying that any use of property which involves or interests the public in some substantial way opens the door to legitimately allowing the public to control it in some fashion. And he says there in the last sentence that the way to get out of it is to quit using your property for that use, which may sound a little bizarre in the case of a grain elevator. What else are you going to use it for? And here in paragraph 9, Chief Justice Waite says, we have to keep in mind that the 14th Amendment was not intended to extend so far as to preclude the regulation of property, including even prices that may be charged by the whatever use happens to be on that property. And then you see he comes down to paragraph 10 saying, This is a domain where it's no longer just a private matter between private parties. And there I've underlined the phrase affected with a public interest. Now, I have omitted here, although you can find it in the excerpted opinion in the reading packet, that Justice Waite appeals to a famous tract in English law from Matthew Hale. The Latin title I've forgotten, but it was about the idea of affected with a public use as it pertains to monopolies. There is one distinction, though, between the case in Britain that Matthew Hale was writing about and the grain elevator in Illinois. What Matthew Hale was writing about in the English context was customs houses at harbors that had been set up by government monopoly, similar to the slaughterhouse in Louisiana in the slaughterhouse cases. Now, the grain elevator in Illinois was established by a private party. It was not a government-granted monopoly. It was not exempt from competition. Someone else could have set up a grain elevator. It was, you might say, a temporary monopoly. And so the comparison between the English case, as Matthew Hale understood it, and the Illinois case is probably incorrect, and that's something the dissenters in this case seize upon, as we'll see in a moment. Here in paragraph 11, we see Justice Waite give a pretty good example of privately owned enterprises that would be monopolistic in practice and therefore pretty easy cases to say are affected with a public interest. You know, if someone owned both sides of a riverbank where people want to operate a ferry, pretty clearly normal competitive markets wouldn't relieve or eliminate that monopolistic power. And so there, I think an awful lot like electric utilities and so forth, you can see the case for regulation pretty straightforwardly. Now, should I say a thing or two about the idea of natural monopolies? Yes, I think maybe perhaps I should. A great example of a natural monopoly, that is to say, the kind of economic activity where you can't expect competitive markets to operate, and where indeed competitive markets might actually be a really perverse idea, would be electric utilities or water companies in cities. I mean, it would be it'd be a waste of resources to run second sets of power lines in cities, second sets of water lines. And that's why, because it's double your infrastructure cost, all that's pretty easy to make out. Railroads operated a little bit that way. Nobody wanted to go to the great expense of building a competing rail line on short-haul rates, although long-haul rates, there was more room for competition to work, so railroads were always a special problem. But electric utilities, it made sense to say, all right, we're going to give a particular company, Edison, right, a franchise or exclusive rights to build the grid and supply electricity to a city, but we're going to regulate the rates. That makes perfect sense too. But in paragraphs 20 and 21, Justice Waite makes a good case for why the grain elevator market in the Chicago area bore all the hallmarks of a monopoly, or at least an oligopoly, noting that even though there is ostensibly competition and free entry and exit from the marketplace for grain warehouses, it operated like a cartel. And the prices were uniform, the prices were fixed by people in the industry, and that's why there at the end of paragraph 21 he says, this amounts to a virtual monopoly, therefore affected with a public interest justifying public regulation. Now here, paragraph 23, which is rather long and dense, Waite says something very important that's going to come back in various forms for a very long time, coming right down to the present day. You'll see that he starts by saying, look, Illinois has a new constitution in 1870. They delegated the power to the General Assembly to pass laws, and he quotes there, for the protection of producers and shippers and receivers of grain and produce. In other words, expressly delegating power to regulate the marketplace for grain and therefore grain elevators. But then starting in the boldface part, right in the middle, he says, for our purposes, we must assume that if a state of facts could exist that would justify such legislation, it actually did exist when the statute now under consideration was passed. And then he goes on to say, this is a question of power. The legislature has the power, not us in the judiciary. And we're going to assume that they're operating on good faith understanding of the facts of how the marketplace works. And so then the last sentence, he says, the legislature should be the judge of the extent of their powers. In other words, as we've seen before and we'll see again, a reluctance of the judges in this case to intervene and quarrel with or contradict the political judgment of the legislative branch. Here in paragraph 24, Justice Waite makes a pretty good argument, I think, that what's happening here is not really novel. Just because there's no direct precedent doesn't mean that you can't make out a continuity between long and well-established principles, he says here, of social science, but also of law, justifying the regulation of private property and private enterprise on behalf of the public. Now here Justice Waite points out that while a lot of people have claimed that a reasonable rate of return is a judicial and not a legislative question, and in fact there are other cases that agree with that proposition, he says here the practice has been otherwise. And he points to a common law tradition where legislatures have declared a reasonable compensation, although once again one can quarrel whether he has extended the common law rules which were directed at genuine monopolies to this more difficult circumstance. But we pass over that for the importance of the next observation. In paragraph 29, he reminds us that legislatures have always been able to overrule common law regulations, unlike, say, a constitutional finding. So in other words, even if you side with the argument that reasonable rate of return is something that should be subjective to court review, legislatures are still paramount over judges in setting rates and regulations. They should have priority. But the important sentence is at the bottom of paragraph 30, where he says, for protection against abuses by legislatures, the people must resort to the polls, not to the courts. In other words, the political branches have to fix this problem. You saw a direct echo of this point of view in Chief Justice Roberts' majority opinion in the first Obamacare case, where he reminded readers that it's not our job to fix bad legislation. If you think this bill is a bad bill or a bad law, then it's up to Congress to fix it, not us. But another question that ought to be kept in mind and thought about when you read Justice Waite saying the recourse should be the legislature is the fact that in Illinois in the 1870s, you had the populism of that time, right? The Grange movements. So, if you're going to put it to the vote of the people, should we regulate grain elevator operators? Pretty clear how that vote is going to turn out. They were the robber barons of their time after a fashion, right? Charge the higher prices they could. You had falling farm prices throughout the entire Midwest during those decades because you had general deflation, result of bad monetary policy, but never mind that. And so one may wonder a little bit about whether the idea that there are certain areas where you want the courts to interpose themselves between transient majorities. You go back to Madison's ideas on passion and faction, right? And so Justice Waite's opinion is certainly very creditable, and a lot of people have followed on it. But on the other hand, again, the question is, isn't this one area where there may be another side of the question, or where you wonder where the court should think about drawing lines to protect various interests from popular control? We're going to see how this comes back in a civil rights context in a few minutes. Justice Stephen Fields, as he had done in the slaughterhouse cases, issued a blistering dissent where he said, look, this essentially is going to open the door to almost unlimited regulation of economic interests. I mean, after all, if you can declare a grain elevator to be affected with the public interest, what other things could you declare to be affected with the public interest, and could you reach through regulation? This is exactly the point he makes in paragraph 44. If this be sound law, if there be no protection, either in the principles on which our Republican government is founded, or in the prohibitions of the Constitution against such invasion of private rights, all property and all business in the state are held at the mercy of the majority of its legislature. And he goes on to say, why not homes that families live in? There's hardly a greater compelling state interest, as we say these days, than in the health of families and their residences. And so this leaves us a little unclear on where the lines are going to be drawn. Fields concludes his argument by saying, look, if we press the idea of affected with the public interest beyond any limit, then essentially all of the constitutional protections for private property and private enterprise disappear. So now before we go on to our next couple of cases, let's stop for a brief intermission. So here's me and my new best frenemy. This is Liz Winstead, who is the co-creator and former head writer for The Daily Show. And we were on a panel together on Monday, and boy, did we have a ton of fun. I mean, how could you not? And no, this is not the Chevron two-step again. This is what passes for a mob at Boulder, and is why Boulder is never going to be Berkeley. People are just too happy. Okay, now that the party's over, we want to turn to our next case, which is the 1938 case of U.S. v. Caroline Products. And this is really a fun one. It involves a company, Caroline Products obviously, that made what was called at the time filled milk, which is not exactly the same as powdered milk. Filled milk at the time could be filled with things that weren't necessarily milk. This is not like your non-dairy creamer that you might use at Starbucks or something. And the disreputable people would sometimes put sawdust in their powdered milk. That's why they call it filled milk. Filled out with something bogus, right? Now, the Agricultural Adjustment Act of 1937, delegated lots of power to the Department of Agriculture to regulate products of this kind. And when the Department of Agriculture banned filled milk or severely regulated it, Caroline Products sued under the Due Process Clause, saying they were being deprived of their livelihood, similar to the claims under the Privileges and Immunities Clause in the slaughterhouse cases and in other cases. Now, once again, there is a legitimate question here about whether the regulation could be generally construed as legitimate police power regulation safeguarding public health, or whether it could have been in the interest of special interests trying to avoid competition. In this case, it would be dairy farmers who want to sell the real milk and not the fake stuff. For a great many years, margarine was illegal in the state of Wisconsin by state law. Why? Because the dairy farmers who made butter didn't want the competition from the new product, even though there's really nothing hazardous about margarine. Filled milk is, of course, a little more ambiguous. Now, Caroline Products lost its case at the Supreme Court, but Justice Stone did not rest the holding on the reach of the police power to protect public health, which would have made sense, or even on deferring to the commerce power directly. Instead, he came up with what was known as the rational basis test, or he crystallized what became known as the rational basis test. But the rational basis test, as we'll explain in a minute, had been implied at least as far back as Munn and the slaughterhouse cases. However, Justice Stone explained this in one of the most impenetrable and lugubrious passages in any Supreme Court opinion, and that's saying a lot because there's so many bad ones to choose from. So take in this god-awful mess in paragraph 10. We may assume for present purposes that no pronouncement of a legislature can forestall attack upon the constitutionality of the prohibition which it enacts by applying opprobrious epithets to the prohibited act, and that a statute would deny due process which precluded the disproof in judicial proceedings of all facts which would show or tend to show that a statute depriving the suitor of life, liberty, or property had a rational basis. Got all that? So let's try and break this down a bit into something comprehensible. What he's saying, that first clause, is that no matter how persuasive or compelling a legislature might be in its legislative intent or finding, of course people are going to attack the constitutionality of some prohibition or regulation. I like opprobrious epithets. That's, pretty flowery language. Now, the second half of this tangled sentence gets to something that is usually called in ordinary law rebuttable presumption. In other words, sometimes you'll presume a law to be valid or certain court proceedings to be valid, but that presumption in favor of the validity of a law is rebuttable in court according to certain standards, certain canons of evidence, and so forth. And so what I think Justice Stone is saying here, if I understand it correctly, and I'm not sure anybody does, is that, of course, someone can challenge the facts of a judicial holding, presumably at the trial court level, but as he makes clear in the next paragraph, we're probably not going to do that much anymore. So paragraph 12 of the opinion is a little better, although still a bit impenetrable in ways. Justice Stone says here, the important part here is right in the middle. Look, the legislature says, here's why we're doing this, and we're going to accept that. And he says, and right in the middle there, that passage, 5 lines down, Even in the absence of such aids, meaning even in the absence of legislative findings and declaration of legislative intent, even in the absence of such aids, the existence of facts supporting the legislative judgment is to be presumed. In other words, we're going to give them the benefit of the doubt that they had a good reason for doing this. But to continue, for regulatory legislation affecting ordinary commercial transactions is not to be pronounced unconstitutional unless, in the light of the facts made known or generally assumed, it is of such a character as to preclude the assumption that it rests on some rational basis within the knowledge and experience of the legislators. Now, as I say, it's only a little bit less tangled than paragraph 10. But what this means is if you bring in an economic regulation to court in front of us and challenge it as a violation of due process or any of the other clauses that are still around, we are going to assume that the legislature had a rational basis for wanting to do that particular regulation or subsidy. But what it means in practice is if you can point to anybody who benefits from a piece of legislation or regulation, we're going to smile upon it and not get in its way. It sets a very high bar for courts now to intervene to block economic regulation. But there is a problem here, which was even evident to the confused and confusing Justice Stone. You'll notice dangling out there on the side, footnote number 4. You have to ask the question, well, if we're going to defer to legislatures and accord them a presumption of a rational basis for legislation they pass, regulating private interest, private behavior, private commercial activity, where do we draw the line? How do we handle a legislative statute that might regulate free speech or certain other activities that you think of as fundamental rights? And footnote 4 is where Justice Stone deals with this problem. And what you should know is that footnote 4 of Caroline Products is regarded as perhaps the most significant footnote of any Supreme Court opinion ever, although there's maybe one or two rivals in other cases. But certainly footnote 4, among the constitutional law crowd, it's almost like code. You just say footnote 4 and everyone knows that you mean Caroline Products. And here is the famous footnote 4, and it comes in 3 parts. The first one there raises the problem I just suggested. I'll read it. There may be a narrower scope for operation of the presumption of constitutionality when legislation appears on its face to be within a specific prohibition of the Constitution, such as those of the first 10 amendments, and which are deemed equally specific when held to be embraced within the 14th. I'll pause here. That's pretty easy to make out. Obviously, if Congress has passed a law abridging free speech, you can point to the black and white text of the First Amendment saying, Congress shall make no law abridging free speech. As I say, that's not very hard to see why the court has to stay engaged and apply what is called strict scrutiny to fundamental political and civil rights. The second one, though, is where things get interesting. It is unnecessary to consider now, I'll pause here and say it will become much more necessary in subsequent decades in civil rights law, but it's unnecessary to consider now whether legislation which restricts those political processes, which can ordinarily be expected to bring about a repeal of undesirable legislation, is to be subjected to more exacting judicial scrutiny under the general prohibitions of the 14th Amendment than are most other types of legislation. So here again, we're going back to a few things we talked about, starting on the first day of class. You remember Martin Luther King saying in the letter from the Birmingham jail, language to the effect of, hey, wait a minute, you're imposing laws on us that because we're denied the right to vote here, we had no voice in making. One of the ideas of democratic participation is you may lose, but at least you get to vote on things. In the South, blacks didn't get to vote on things for the most part. And so here, would you want to extend the presumption to legislatures regulating processes that might allow majorities to speak? And that is, this point is dilated further in a third paragraph. So, by the way, we don't need notice that it's unnecessary to consider now, the third one, nor need we inquire. But clearly Justice Stone is saying that he recognizes they've created a problem with this distinction between a rational basis in deferring on economic matters and strict scrutiny for other things. In other words, we have now created 2 tiers of Supreme Court review. The 2 poles are the rational basis test, Scalia used to like to call it the babbling idiots test. You can think of any reason why a law will benefit somebody, the Supreme Court will give it a pass. And strict scrutiny on especially in civil rights areas, where the court will be very intrusive and wanting to make sure you've really justified a law or regulation. And so the third qualification in the last paragraph there is nor need we inquire whether similar considerations enter into the review of statutes directed at particular religious or national or racial minorities, whether prejudice against discrete and insular minorities may be a special condition. When you get to the 60s and 70s and a lot of the civil rights case, you see that phrase, discrete and insular minorities, come up in a lot of the civil rights laws. And so even though Caroline Products was about economic regulation, that particular phrase and this particular framework becomes very important for civil rights law. Of course, once again, I think you can ask the question, racial minorities, women and other of the what we now call protected classes in civil rights law, wouldn't say Uber drivers be a discrete and insular minority in the municipalities that try to regulate them or ban them because they don't want the competition for the taxi companies? It's one of those odd cases where if a city banned Uber drivers, the city would say, yeah, you can do that. If a city passed a law saying no Hispanic Uber drivers, the court would step in 5 seconds to say you couldn't do that. Once you start down the road of deference paved for us by the Caroline Products case, you come to a whole line of cases that make you wonder whether the judiciary has surrendered too much of its authority. So, for example, one sequel case from the 1950s is Williamson versus Lee Optical, concerning an Oklahoma statute that said that prescriptions for eyeglasses could only be filled by optometrists and not by your local Sterling optical shop or the kinds of things we're used to patronizing today. Here is Justice Douglas's opinion in Williamson versus Lee Optical, and he starts off by saying, well, this law may be needless and wasteful, but it's for the legislature, not the courts, to balance the advantages and disadvantages of this requirement. And then he goes on to say, maybe the legislature thought that it was necessary to, protect people from unscrupulous eyeglass sellers. I don't know. And then he goes on to say, the law need not be in every respect logically consistent to be constitutional. So the point is we're not going to second guess the legislature. And then as a coda at the end, he says there, the day is gone when this court uses the due process clause of the 14th Amendment to strike down state laws regulatory of business and industrial conditions because they may be unwise, improvident, or out of harmony with a particular school of thought. Here he's sounding an echo of Holmes, I think, in the Lochner case. But is it really beyond the reach of judges to wonder about whether you have class legislation, arbitrary legislation, legislation that was imposed by a special interest? Those are tough calls, but I think maybe not impossible. But no, Justice Douglas, one of Roosevelt's New Deal era appointees to the court, said, this is all quite beyond us. Courts really can't be engaged in making these kinds of discriminations. And the irony here is that Justice Douglas, although a noted liberal, was actually quite sophisticated in some of the utility rate cases and utility regulation cases that came before the court during his time on the court. There he proved quite adept at dealing with very complicated matters that many other justices said were just beyond them. Or my particular favorite is a case from 1976 called New Orleans versus Dukes, which concerned a woman named Nancy Dukes who operated a hot dog push cart in the French Quarter of New Orleans. Well, along came the New Orleans City Council, which passed a new ordinance that said on the surface that no one could operate a push cart in the French Quarter of New Orleans unless they had been in operation continuously for at least 8 years, because everyone has to have a business license to do such. Now, the ordinance had the effect of putting only one person out of business in the French Quarter, and that was Nancy Dukes, who brought a suit saying that her livelihood had been taken away from her without due process of law. And the Supreme Court essentially said, well, we don't know what the city council is up to, but we see nothing here that bothers us. Now, this is New Orleans we're talking about, right? And what do we know about New Orleans? Well, it doesn't have the reputation as the most corrupt city in America for nothing, And so there's lots of suspicion that behind the scenes you had competitors to Nancy Dukes who wanted to put her out of business. So now, it's no doubt the case that the New Orleans City Council has got a legitimate or rational basis for wanting to limit the number of hot dog purveyors in the French Quarter. You don't want them overrun with t-shirt sellers and food purveyors and so forth. However, this looks clearly like an arbitrary piece of legislation aimed at one person. It would be quite possible to think up a rational policy to limit the number of hot dog vendors, such as apportioning licenses by auction, apportioning them by lot, or other ways that would have been non-discriminatory against one particular person. But to sum up the standards of review that emerged in a crystallized form out of Caroline products, we apply strict scrutiny to a fundamental right, which will include civil rights, but also legislative enactments that may bear on civil rights even indirectly, like voting laws and other patterns of discrimination by employers, things we'll get into next week and the week after. But if it's not a fundamental right, realize that we're saying that economic rights are not fundamental rights, then we apply rational basis review, which means that except for extreme cases, what the court and Congress later said was arbitrary and capricious regulation, you're going to get a free pass from the Supreme Court to do pretty much anything you want to. This brings us to our final case of the day, the 1984 case of Chevron versus NRDC, the Natural Resources Defense Council. This was a case that grew out of moves by the EPA to implement some very arcane aspects of regulations arising under the Clean Air Act as they pertain to stationary sources or industrial sources of air pollution, like oil refineries and chemical plants and manufacturing plants. And the EPA wanted some flexibility to allow industries, particular locations like oil refineries and chemical plants, to not necessarily follow precise regulations on every single piece of equipment they had, but to allow them flexibility of which modifications they made of the plant, so long as it did not increase air pollution from the plant. Well, environmental groups, of course, they like to sue over these things, and they want as strict a regulation as possible. And the NRDC favored very prescriptive application of the regulations right down to individual valves on different aspects of an industrial or chemical site. And so they sued the EPA. Really, it's really a case against the EPA, but the form of it is NRDC versus Chevron, because it was Chevron's permit before the EPA that gave them the opening to challenge the EPA's measures. Now, the problem, of course, is that a lot of congressional statutes are very vague or general and delegate a lot of authority to the regulatory agencies. The Clean Air Act is very long. It's very precise in some places like tailpipe standards for cars. But when it came to oil refineries and chemical plants, it was impossible to prescribe detailed regulations in the statute itself. And so although the technical aspects of this case are arcane and wonky, when it comes to a court reviewing a regulation, the first question is really pretty simple. Let's look at the statute and see if it's clear what kind of instructions Congress was giving to a regulatory agency. That was easy to do in the case of, say, the Food and Drug Administration and the Pure Food and Drug Act 100 years ago, but modern regulation is more complicated. And so if the statute is ambiguous or unclear, then the court asks a second question, or step two as it's become known, which is the regulatory agency's construction of the statute reasonable from some point of view? And here the court says in the key paragraphs of it, we're going to accord great deference, just as the courts in Caroline products said we're going to defer to legislatures. Here the court says we're going to defer to the regulatory agencies and not substitute our own judgment or strike down a regulation unless it's clearly arbitrary and capricious. And even with those terms, arbitrary and capricious, we should pause long enough to note that those words come to us not from a Supreme Court case, actually, but those are the words used in the Administrative Procedure Act of 1946. That's a long statute that set up what the rulemaking process is supposed to be for regulation, coming out of the New Deal when there was an awful lot of chaos and inconsistency in how regulations were made from agency to agency. And it's the Administrative Procedure Act that gives us the notice and comment period, the formal notice in the Federal Register, and all the things you have to go through before a regulation is finalized. And that also sets up what are the standards for being able to get into court and what kinds of issues from the rulemaking process can be reviewed in court. And it's there in the APA, Administrative Procedures Act, that says that courts should not be striking down regulation, unless it is clearly arbitrary and capricious. Now, of course, there the problem is what's arbitrary and capricious, and that has been left to the courts to develop some kind of boundaries or standards or bright lines, and it still once in a while happens that a regulation will fail an arbitrary and capriciousness test, but it's increasingly rare. The heart of the opinion is in paragraphs 4 and 5, written fairly clearly by Justice Stevens. You can see they're underlined. First is the question of whether Congress has directly spoken to the precise question at issue. And if the intent of Congress is clear, that's the end of the matter. But then it goes on to say, paragraph 6, if Congress has explicitly left a gap for the agency to fill, there's an express delegation of authority to the agency to elucidate a specific provision of the statute by regulation. Such legislative regulations are given controlling weight unless they are arbitrary, capricious, or manifestly contrary to the statute. And then concluding at the bottom, the court may not substitute its own construction of a statutory provision for a reasonable interpretation made by the administrator of an agency. So, in other words, we've gone from Caroline products with the courts deferring to Congress or legislatures. Chevron says let us defer to regulatory agencies in interpreting statutes. And then there's a third step to this in a later case that I'm not going to have you read or go through from 1998 called Auer, A-U-E-R. And it simply proceeds in logical fashion. Here is the question is, how about the enforcement or application of a regulation? Can you challenge the way a regulation is enforced by an agency? And there the court said, yeah, it looks to us kind of like Chevron. In other words, we're not going to second guess the application of a regulation by an agency unless, again, you can make some kind of case that it's arbitrary and capricious. And so an awful lot of the regulatory challenges today try to make arguments about why a regulation is not entitled to Chevron deference or why the application of a regulation that may itself be legitimate is not subject to our deference. And the great irony of this case, as I think I've mentioned a couple of weeks ago briefly, is that the environmental group, the NRDC, that brought the suit wanting stronger regulation, lost the case. But of course, recognize that if you give a regulatory agency deference, it means that you will also defer to them as a court if they're doing stricter regulation. And so guess what? The Chevron doctrine is now the favorite legal doctrine of especially environmentalists, but people who like the regulatory state generally, which is why it has become controversial because bureaucratic behavior being what it is, once you're given a get-out-of-jail-free card by the Supreme Court to do pretty much anything you want and be assured that your regulations will survive pretty much any legal challenge, well, like the takings clause, if takings are free, you're going to regulate a lot, or at least a lot more than you might if there was a stricter standard by the court. At the end of the day, the Chevron case, for all of its complexities on the technical level, turned on the interpretation of a single word, what the word source means. Well, that's going to be it for the day, but here's a few summary comments about this whole current unit of things. I've had occasion in the past to remark about how Chief Justice Marshall, in his early landmark decisions about the Commerce Clause, the Supremacy Clause, and the Contracts Clause, had what might be made out as a pro-capitalist bias, or at least he was pro-competition. And one of the remarkable things to appreciate about the Constitution is that it does favor competitive markets and has embedded in its philosophy the idea that individual liberty and restraints on government power to reach into individual liberty is actually the most compatible form of the rule of law with the idea of vigorous economic growth. And it's remarkable the congruence between that legal architecture and modern economics, because after all of those early decisions, as well as the Constitution itself, were written at a time long before you had the really advanced understanding of markets and the benefits of competition from economists like Alfred Marshall or even David Ricardo early in the 19th century. And although Adam Smith was known by some of the founders like Hamilton, you don't really get from their handiwork that they thought that Adam Smith was the guide for their jurisprudence. And so we have a commercial republic, albeit without a fully developed or internally consistent constitutional theory of a commercial republic. Its pro-commercial bias, derived both from the philosophy of individual liberty and the common law tradition, and a few other places, can perhaps be seen as a happy accident. The gaps, inconsistencies, and vagaries of the Constitution are perhaps for the best, and may explain why it has been so enduring. It has enough play in the joints to allow us to move, even if we stumble a lot and lose direction. So good luck to everyone on the quiz, and I will see you back in class next week when we will start into modern civil rights.